we go live? Steve, let's go live. Hey, Steve, can we go live?
Yes, Tom, we are live. Okay, yes, we are live.
Hey, everyone. This is Tom Kemp. Thank you for waiting here. And so, Steve, can you show me as well? Just flip it so that we can show me. Ah, there we go. All right. Hi, everyone. My name is Tom Kemp. So I wrote a book called Containing Big Tech that talks about privacy and AI. And I said, hey, let's give the entire community an update on where things stand on US privacy and AI regulation with people in know. So I'm pleased to have the following people as speakers today. Our first speaker is Representative Ro Khanna. Ro proudly represents California's 17th Congressional District, located in the heart of Silicon Valley, and is serving his fourth term. He serves on the House Armed Services Committee as the ranking member of the Subcommittee on Cyber Innovative Technologies and Information Systems. He's also the author of Dignity in the Digital Age. So, Ro, welcome aboard.
Thank you, Tom. Excited to be here and excited about your book, Containing Big Tech. I thought it was fantastic and looking forward to talking about that and other issues.
Great. Okay, so thank you, Ro. Our second speaker is Alastair Mactaggart. Alastair is chair of Californians for Consumer Privacy. He is the author of the California Consumer Privacy Act and the California Privacy Rights Act. He's also a board member of the California Privacy Protection Agency, but is speaking in an individual capacity today. Alastair, how are you?
Great. Good morning, Tom. Good morning, everybody. And yes, thank you for clarifying that I am here in a personal capacity, not representing the agency. So any comments are from me alone. Thanks.
No problem. Our third speaker is Dr. Jennifer King. Jennifer is a Privacy and Data Policy Fellow at the Stanford Institute for Human-Centered Artificial Intelligence. From 2018 to 2020, she was the director of the Consumer Privacy at the Center for Internet Security. She's also written a lot of great articles on Tech Policy Press, one of my favorite websites, with Justin Hendricks, and I quoted a lot of her articles in my book. So Jen, welcome. Thank you for joining us.
Good morning, and thank you, Tom, and thank you for quoting me. I appreciate it.
Yeah, no problem. Okay, so there are two moderators and co-host. And so I'm moderator number 2. Moderator number 1 is Shilpi Agarwal, and Shilpi is the founder and CEO of Data Ethics for All Foundation. She's also a data philanthropist and former adjunct faculty member at Stanford. Shilpi will be asking the AI questions, and when I transition over to the AI questions, I'm going to have her describe what Data Ethics for All is. So, Shilpi, thank you for joining us.
Pleasure to be here, Tom and everyone. Excited for this conversation.
Okay. And then there's myself. I'm a Silicon Valley entrepreneur. And as you can see on the next slide, I wrote a book. It's called Containing Big Tech. And so I'm really pleased that to kind of celebrate this webinar right here, that my book came out at the same time. It's actually a top book on computer and internet law and privacy and surveillance, so check it out. I'm also the co-drafter of the California Delete Act, Senate Bill 362, that's coming up for a big vote this Friday. And then finally, my last slide here is I'd like to thank Shilpi's organization for co-hosting this event with me. And I would like to thank Steve Tout, my producer, and his company, Nonconformist Innovation Media, for helping make this happen. So I'll lead off the questions regarding privacy, and then I'll hand things over to Shilpi for the AI questions. When I hand things over to Shilpi, I will be checking the chat online. The questions online. So what I want you to do is type question for Ro, or question for Alastair, or question for Jen, and then I will try to field your questions. So let's jump into this, and let's start with Ro. So Ro, as you write about in your book, Dignity in the Digital Age, back in 2018, you drafted an Internet Bill of Rights. But here we are in 2023, and we have no national US privacy law. The EU has the GDPR. We now have 12 states that have comprehensive laws. So probably an obvious question or answer right here, but why are we in this situation with no federal privacy law?
Well, it's unacceptable. I worked on the Internet Bill of Rights with Tim Berners-Lee, and the principles are simple, making sure that people own their own data, that they have to consent before their data is used, that data is used only for the purposes that businesses actually need and not have excessive data, that people have a fiduciary, companies have a fiduciary responsibility to individuals' data. And of course, the California law was a big step forward that Alastair and others led. The challenge at the federal level is we want to have a national standard that has California as a floor, not one that would dilute the California standard and then preempt the California standard where the privacy would actually move backwards in California. And a lot of the debate has been how do we get a national bill that has at least the safeguards and protection of California. There are efforts that would have a national standard that would be weaker than California, but that would be moving backwards for California. And a lot of the gridlock has been on how do we get something where California becomes the floor.
Okay, so look, at the House level, I mean, so obviously the ADPPA, the American Data Privacy and Protection Act, did pass the House Energy and Commerce Subcommittee. Do you see anything happening on the privacy front coming out of the House this legislative season? I did see the Fourth Amendment is not for sale passed, which involves the sale of data from data brokers to the government. That did pass through the House Judiciary Committee. So from a House perspective, is there anything, be it a comprehensive or maybe on the periphery in terms of like with data brokers, do you just see anything happening in the House, or just are we kind of in a kind of a dysfunctional era right now that even we can't get anything even more incremental coming out of the House?
I'm hopeful we can get something, and the challenge again will be that it doesn't preempt provisions of the California bill that are stronger, because obviously when you have federal legislation, you'll have preemption, and the federal law will be there and supersede a lot of the state law. And that's important. You don't want 50 different standards. I mean, everyone is for having some national standard. But the California delegation, Speaker Pelosi, myself, others, have been saying that, and ASHU, that we need to have at least the core parts of California protections in any national legislation. It doesn't mean it has to be perfect, doesn't mean it has to have all parts of the California legislation, but the core protections need to be there. And that's the process that's playing out. I'm hopeful we can get something done.
Okay, so on the Senate side, there seems to be a lot of activity. For example, the Kids Online Safety Act, or KOSA, was reintroduced. KOSA is like California's AADC, the Age Appropriate Design Code, that requires online services to prioritize kids' well-being and best interest when designing their services. Now, there are other bills in the Senate that are focused on restricting children on social media and requiring platforms to verify the age of all users. So what are your thoughts on these type of bills, like identity verification for kids? Do you see any of them? I mean, so what is your thoughts? Do you see any of them making it over to the House? Obviously, you represent Silicon Valley, and there's just an issue with kids' safety and the products being designed for all populations and not carving out or taking into account the needs and requirements for kids.
I do. I think this is something that is long overdue. I mean, you have a epidemic of mental health issues, particularly for teenage girls on social media. 1/3 of teenage girls in this country have contemplated suicide. It's a staggering number. Not that they all need medical attention, maybe 1 or 2% need medical attention, but just the fact that they've had those thoughts. And social media is not a dispositive factor, but it's a contributing factor It's like their worst experience in junior high on steroids. And so we need to take decisive action. One, we need to make sure that the young people under 13 aren't on these sites, and that's actually being enforced. There ought to be strict liability for companies to have some sense of age verification. And we need to make sure that the design of these platforms are with the well-being of the child in mind. And if that means you can't have excessive likes and shares and retweets and algorithms that amplify the most dangerous aspects of eating disorders or things that cause mental harm, then that's what we need to do, and the FTC should regulate it. I'm hopeful we can get something like that through this Congress.
Okay, thanks. So let's shift gears more to the state level, and let's bring Alastair in. So first of all, Alastair, congratulations on passing both the CCPA through the legislature in 2018 and the CPRA through the ballot initiative process. And so full disclosure, I worked with Alastair on Prop 24 here, and Alastair's become a good friend, as is Ro, through the years. Since then, since CPRA, we've actually had many reports regarding how the tech industry is writing other states' privacy laws. So what do you see to be the main differences between California and other state laws that are being passed?
Well, just let me say a couple things first about your involvement, because I just want to say, your book's come out. Not only were you involved, you were incredibly helpful during the campaign. For anybody who doesn't know, I didn't know Tom. He was a volunteer. He's the volunteer of all volunteers, and he's the one who helped with marketing. Unbelievable. He's the one who discovered right before the election that Google's snippet no longer pointed at the official nonpartisan title and summary from the Secretary of State's office, but pointed to the opposition summary, not once, but twice. After they fixed it, came back again. So Tom, forever in your debt. And Ro, hearing you say what you're saying about social media there, I couldn't agree more. And it's wonderful having people, leaders like you at the national level, considering these things thoughtfully. So Tom, getting to the state level, what I would say is, I categorize it as to laws that I think are good and privacy protective laws. There's some laws that I'm not as fond of in terms of their privacy protections. But if you think about one way to look at the laws that have passed in the states, is do they mandate that the businesses respect a global opt-out? And so obviously California does, Colorado, Connecticut, Montana, Oregon, Texas, and now I think Delaware, if it gets signed by the governor. All of those laws will require businesses to accept and respect a global opt-out. So what this means is 1 in 4 Americans will have this right. I think this is one of those fundamental kind of rights, which is going to eventually become the standard. And just if you think about California's experience with auto emissions, we set the standard for auto emissions. There are, I think, 13 states now that I just went through and looked at it that currently, there's a couple more that are coming, but currently adhere to the California standards. That's about just over a third of the population. And so using the analog of the environmental of the air regulation, if our standards that then get adopted by 12 states or 13 states that then represent about a third of the country, force essentially automakers to say, and we're just going to adhere to the strictest standards because we don't want to have a whole bunch of different standards. I think the analog is going to be in the opt-out world. It's going to be very hard I've always believed this, but the more states that adopt this, the harder it's going to be for companies to say, yeah, we're going to respect your global opt-out in Colorado, but we're not going to respect it in New Mexico, and that's going to be hard for those businesses to do because people will be used to it. They'll travel and they'll say, why doesn't that work here? And so I see that there's going to more and more be something that's frictionless for consumers. It'll come with the devices. It'll come with the browsers. And people's expectation will be, hey, you know what? In general, my information is not being used for a purpose that I don't sort of understand and agree with. And so, I understand they need to use my sensitive data to get the car to me right here at the street corner. I don't expect them to be selling the fact that I'm being picked up at a dialysis clinic or at a mosque or at wherever I am right now. So I think that I'm hugely gratified that so many states have adopted what I think is really good legislation. And in some cases, look at Colorado, they go further than ours in terms of they encompass nonprofits. So, which I think is a next step, obviously in this state too. So I'm not as doom and gloom just because we don't have a national law. I'm still very positive about where the country is headed. Can
you double click a little bit more on the global privacy control and just talk a little bit more about that, please?
Yeah, that's an interesting one. This is the notion that you should be able to set something in your browser or your device that tells all businesses, hey, I don't want my information sold or shared for advertising purposes. In our case, I don't want my sensitive personal information used. I don't want my sexual orientation, my religion, my health status. I don't want it used unless it's absolutely necessary to deliver the services I'm asking for. And I don't want to have to go through a whole bunch of stuff. Like right now, we're in the world of cookie banners and, okay, cookie pop-ups, how do I use my information? In GDPR and here as well. And I think we're where I envisaged the world getting to and why we wrote the California statute the way we did is to incent businesses to get to a world where they just do this. Like the regulations that are coming, if you look at them, the statute says every single web page that collects your information has got to have the do not sell link on it, every single one. So I think once that really goes into effect and companies think about this valuable real estate on a mobile screen and having a do not sell button versus just respecting your global opt-out, they're going to go to the global opt-out. That's the incentive. That's the quid pro quo. And I think that everybody's going to respect it, which is going to make for a much better experience for consumers. So that's what the global opt-out is. It's something that's simple, set it and forget it. That's the idea.
So, I mean, and I'm seeing some pushback here. I mean, what is the message on the chat right here? Why is it important that California law not be preempted as we look at federal law? I mean, people may say, geez, why, California just one state, et cetera. I mean, what's kind of your general argument for the rest of the nation?
Is that me or the representative?
No, that's going to be you, Alastair.
Okay. So my argument is, first of all, look at California. Our initiative process, the reason it was worth spending all this time and money in California is our initiative process is unbelievably robust in the sense that what the initiative says is that the legislature in California can amend this law in any way that is privacy protective. You just can't roll it backwards. And that is that's a forever guarantee, more or less, unless someone else writes an initiative that says we want to take away privacy protections. That's probably not going to happen in California. So we have a situation where 1 in 8 Americans have this essentially guaranteed privacy floor. What's so powerful about that is that's kind of there. Now, if Congress comes along and gets rid of that, that then is a world. If you look at ADPPA, there were so many areas where it was weaker than California. Like it didn't cover government entities. There was no profiling protections. There was no AI regulation. We are now the de facto AI regulator for the country. There are all these areas where ADPPA was much, much weaker. And it just gave all the authority to the FTC to regulate in the future. And so that you could have regulatory weakening. So what I would say is I'm a huge fan of a federal privacy law. Of course, Americans deserve protections. But what actually happened is for 30 years, industry was sitting there telling Congress, hey, you're too stupid to regulate this. We're the golden goose. We're the wonder child of the American economy. Don't mess with us because you don't know how. And by the way, self-regulation is the best regulation. Then as soon as California got strong regulations, all of industry ran to DC and said, hey, by the way, we get it. We need privacy protections. And by the way, what we should do is we got to preempt California and get rid of them and make it a privacy ceiling, not a floor, as the representative was talking about. And one thing just to leave people with, think about HIPAA, federal health law. Think about GLBA, privacy, financial law. All those are federal laws that can protect privacy, and they're a floor. They're not a ceiling. The states can go further. So there's no reason why an omnibus consumer privacy law couldn't be and shouldn't be a floor. It should be a floor. And let the states be the laboratories of democracy they're supposed to be. Let them go further. I mean, look, we've had 12 states adopt privacy laws, and the feds are still kind of sitting there trying to figure it out. Of course, the states can and should move faster. And there's nothing about this particular subject that's magical, that it needs to be a federal privacy ceiling, and somehow we can't possibly have different states with different, because guess what? We're all asking for the same thing. We want to have our data, want to have access to it, want to be able to delete it. We want to make sure it's not being used for nefarious purposes. This is not rocket science in the sense of all the states are roughly going to be asking for the same thing.
Thanks, Alastair. Okay, Jen. So the FTC has gone after Amazon regarding its use of dark patterns with respect to unsubscribing to Amazon Prime. But we see the use of dark patterns that thwart consumers being able to exercise their privacy rights. Now, you've written a lot about this. Can you define the problem, and where do you see things going with respect to legislation or rulemaking with respect to dark patterns and privacy?
Sure. Thanks, Tom. First, yes, the FTC has gone after Amazon. Yes, the FTC. And actually, let me just say briefly what are dark patterns. Let me just say briefly what are dark patterns. We're talking about are design patterns that are used to coerce design patterns that are used making a decision that you may not otherwise making a decision that you may not. In the case of Amazon, the question of Amazon, people are trying to unsubscribe from Amazon
Prime, and they're being prevented from doing so primarily by tricks, or we call them dark patterns, or manipulative design in the user interface. So things like pre-selected checkboxes, or you get renewed and you don't get advance notice. So that's kind of the world that we're talking about here. So the FTC, I would argue, has sufficient authority to regulate in this area. I think where it starts to get a little bit more dicey is that most of the cases that have been brought to date have focused on deception. And I think we're going to see more instances that center around questions of unfairness rather than just flat out deception, things that are actually, lying to you or misrepresenting versus things that are misleading, or in cases where really consumers just have no kind of alternative than what's being presented to them. And so in the privacy space specifically, and as Alastair is well aware, the CCPA has specific language in the rules that direct companies to not use particular types of manipulative design in opt-outs. So if you are trying to exercise your privacy rights, you can't be asked questions like, do you not want to not sell your personal information, for example. That one's specifically called out. I've done a little bit of study of the do not sell mechanisms that companies were using right after the law went into effect. And we've seen a lot of misleading buttons and sliders and things in the interface where you can come to a page where you're supposed to be able to either opt out of having your data collected, or exercise your do not sell right, and it can be unclear like what state you're actually in. If I click the button one way, am I actually saying please don't sell my information? Do I leave it if it's saying please don't sell? So the CCPA added some clarity around that, and then we'll see kind of what happens, I guess, when Prop 24 goes into effect. Whether we see any other kind of changes that need more particular attention. But I think the kind of areas that we need to keep a lookout for are what I'm calling algorithmic deception or algorithmic manipulation. So to date, a lot of what we've been seeing are things that are in the user interface, things that you can potentially perceive, like a checkbox that's been pre-selected, or if you not really a privacy example, but if you're, let's say, trying to book an Airbnb where all the fees aren't disclosed until the very last screen. I mean, these are things that are generally kind of everybody sees them. You might see maybe a different form, but more or less they're being presented to all consumers. The area that I'm concerned about is the extent to which we may see things that are algorithmically generated, as well as those things that are algorithmically generated that actually use your personal data in order to target you for specific types of online manipulation. So that to me is kind of the potential new frontier to keep an eye on, to see how well regulators can identify and respond to those types of threats.
So you obviously are at Stanford working with the artificial intelligence group there. Even if we pass a law like ADPPA at the federal level, what gaps remain in terms of the data used for AI?
So we need a bill like ADPA, and I agree with my fellow panelists. I hope it is a floor and not a ceiling. But individual rights just simply aren't enough. And the reason why they are not enough is that we're dealing with systemic threats to privacy. And so you can do all the opt-outs you want, and you can make all the do not sell requests, and those will make some difference, maybe on a small level. But the problem is the widespread systemic data collection that is going on in society today. And so actually, mechanisms like global privacy control, again, will help for sure. But that is not necessarily the kind of only way we need to fight these issues. And so, for example, in the last, September? So the last like 9 months or so, we've seen just an explosion in the world of generative AI. And the problem that generative AI poses is that generative AI is generally being developed by scraping and ingesting as much data as these companies possibly can. And so there's very little transparency into that. We don't know where they're scraping. We don't know what's being scraped. But it is, from all reports, extremely widespread. And as an individual, there's kind of only so much I can possibly do to ensure that I somehow can try to control the data in these cases that's actually being scraped. And so some of these, the extent to which AI in general, but also specifically generative AI, really requires massive amounts of data. This becomes a problem that individuals just on their own will have kind of a limited capacity to solve for ourselves. And so this is where we need to start thinking about what are the systematic kind of societal widespread controls we might need on data collection and reuse and sales that isn't so dependent on each one of us, flipping a bit in our browser or, flipping a setting on our smartphone. Because these are things that even if you do care and you try to proactively take care of these or exercise your rights, there's only so much you can do when data is being vacuumed up kind of everywhere you look.
Okay. Hey, so thank you. So sorry about that little technical difficulty. So, hey, so we're starting to talk about AI here. And so this is a great segue. So I'm going to have Shilpi lead the questioning on the AI side of things. But Shilpi, before you start asking folks some questions, can you introduce your organization and then go ahead and talk about, then start asking the folks some questions?
Yeah, absolutely. So the mission of Data Ethics for All Foundation is to build an ethics first data plus AI world. And what does that mean? What does ethics first mean? It means that ethics need to be at the forefront of all decision making, whether it is from design to development to deployment. And with that, I think we can get started with questions. We have so many questions, and I want to start with questions for Ro. Are you ready?
Sure.
So you represent Silicon Valley. What is your philosophy about balancing innovation and consumer protection when it comes to AI?
Well, that's a great question. Obviously, AI is going to do a lot of things to enhance productivity, enhance the customization of medicine. Imagine someone has a trip to the emergency room and you have symptoms and the doctor takes out a device and says, here are the symptoms, what are the possible diagnoses? In that way, AI can augment accurate diagnoses. It can help customize the appropriate medicine for an individual. It can be used as a tool in education. But any technology can also be abused. And the main thing is to have regulations that ensure it's not used, that if it's that there is human judgment and AI isn't just making decisions without human judgment, that we are cognizant of what data is being fed into AI and know that ultimately AI is a pattern detecting software that's dependent on the information, and that there's some quality control and disclosure of what that information is that's being fed into it, that there's appropriate compensation if original works are being used to churn out new products. So I would say it's complex, and I don't have a view that it's all good or bad. I think it's going to have many positive uses, and it's the jobs of policymakers to have smart regulation so that it has more benefit to society than harm.
I completely agree with you. Definitely a lot of good use cases, a lot of places where things can be automated. We should use AI to automate things or augment things, help assisted decision making. But when it comes to making the decisions themselves, AI tools need to have regulations in place. So what are some that you're hopeful about AI and things that keep you up at night?
Well, I think it's important to realize what AI is not, and it's not right now artificial generalized intelligence. I mean, it is a sophisticated software prediction of patterns of detection, and from those patterns, auto completing the thought that you may have. It takes a large amount of data and then sees what the pattern is and generates other probabilities. So my concern would be that we just on rote have AI making critical decisions because either the data that it's operating from could be flawed, or it's missing ethical dimensions or vectors of thinking that would render the decision it's making incomplete. I mean, if, for example, AI is tasked to complete some goal and it has to do unethical things to get there, it may not be taking those considerations into account if it's only maximizing for optimizing a certain pattern. And that's why I think human decision-making, human check is incredibly important. I also think we shouldn't be getting used to the devolution of standards. From my experience in ChatGPT, it's a long way off from producing anything close to Hamlet, probably anything close to even Oppenheimer. But it can produce C-level entertainment. And the question is, if we don't have the appropriate standards and approach, do we just get people used to a lower standard of entertainment and art because of AI that takes away the imagination and insight? And I think those are important questions that we have to have, both ethical standards and policy standards.
Thank you for that. What I'm hearing repeatedly is that AI can be used for good, but it can also be used for bad. And so we need to have guardrails in place. We need to have better policies in place. So what is needed, according to you, at the federal level to put these safeguards in place around AI? And have you seen any such proposals in motion that you think could pass this year?
I have said that we need to have a commission composed of the leading technologists, ethicists, technology leaders, and societal leaders, nonprofits, to help come up with some of these recommendations. Right now, the White House is led, but it's largely been voluntary commitments from some of the big companies, and there hasn't been the holistic recommendations of policy. That should be the job of the United States Congress and the White House, but I would feel much better if it was informed by a group of technology leaders, civil society leaders, in helping make recommendations. And I'm working with the White House and with the Congress to try to convene such a group.
That's awesome. Thank you. Thank you for doing that. I think that is just what we need. We definitely need technologists who understand the domain to be working with the Congress to create such laws. I'm going to now ask questions to Alastair. Alastair, are you ready? All right. So you had an interesting quote in Bloomberg regarding California a while back, stating that California will become the leading nation in terms of regulating automated decision making, which basically overlaps with AI. When you wrote the CPRA, you deliberately left regulations regarding automated decision-making out of it. So what was your thought process in leaving it out and leaving it for the CPPA to write regulations regarding automated decision-making?
Well, thanks, Shilpi. One of the things we did while we were writing the CPRA, Ro Khanna and I, and Ashkan, and a bunch of different people, we were trying to be flexible. And so, we, as I said earlier, we give the legislature the right to change this in any way that's privacy protective, to keep on changing it with the times. But B, this area was obviously coming. I'm not going to say we could predict like how ChatGPT was going to show up and in what form, but we definitely knew this area was going to be incredibly important. And sometimes less is more. So we deliberately did not define automated decision making because, what's interesting, I think when you look at the Venn diagram between AI and automated decision making, I mean, is it 100% overlap? And as Ro just said, this is not a generalized artificial intelligence out there. What it is this very, very sophisticated software program. You put in some prompts, and you get out some data, and that's automated decision making. So I feel like what we did, I think appropriately, was we allowed for the regulator in the future to come up with regulations that'll change over time, and they should, as this area changes over time. So that was our thought process, is to allow maximum flexibility.
I mean, that makes sense. So we don't know. We are in the state of a lot of unknown, and you're leaving room for improvement as the time evolves and as regulations are needed. All right. So do you think that CPRA and CPPA are sufficient to put some core regulations around AI, or do you see yourself writing a major California bill specifically regarding AI down the road?
I kind of going back to what I said, I don't actually, I think we have a statutory requirement to, as the CPPA, that the board, the law gives the responsibility and the requirement to issue regulations surrounding opt-out rights for automated decision-making and for profiling. We do define profiling. And so to the extent that, consumers' personal information is used in this process of AI, this is incredibly far-reaching and broad, and I don't think there's anything else needed. I mean, I think we are the de facto, and I don't say this in a sort of we're the fourth largest economy in the world. We have, 1 in 8 Americans, but at this point, we're the de facto AI regulators, or will be, because there's not really anybody else who's got this broad a mandate and this big a sort of pulpit to regulate from. So we're in the process of considering, obviously publicly we're in the process of considering regulations right now. And I don't think that the agency needs any additional statutory authority. It has it very clearly. And so I don't think we need anything else.
Thank you, Alastair.
And let me just say, I think that's one of the things that ADPPA missed. And I think and I've had this conversation with people before. They don't really understand. They're like, oh, but, we need to regulate AI. And I say to them, well, what's missing? We have it right here. And so, it's only in one tiny little section, but that's all it takes. And so when people kind of see that, their eyes open, they think, oh, I get it. Now I see that really California it is poised to regulate AI. And hopefully we do so in a thoughtful and productive way.
That's very interesting. So I think it looks like we need a little more education and awareness around that regulation and what is already there in terms of law, so that people know that we have that already. California already has that in place. So my next question is to Jen. Hi, Jen.
Hello.
How might the CCPA's automated decision-making provision impact the use of AI in California or other provisions of CCPA?
Sorry. So apologize earlier. I don't know what happened to my audio. I have no idea what people heard and what they didn't. So, but I'm happy to do any follow-up questions if needed. So, I mean, Alastair is absolutely right. The ADM provision is going to impact AI. You just mentioned a need for education on that point. I'm actually in the middle of writing a white paper on this very topic, and I hope to be finishing that up in the next couple months. That attempts to really explore this issue, because it's my sense, much like Alastair just said, that I think there are a lot of folks in California who might be working in this space who don't quite understand that the form of AI they may be using will be subject to California regulation. Of course, the key piece of it is the personal information piece. And I guess relatedly, and I know I always put the caveat, I am not a lawyer. So I study policy and I work on policy, but I'm not a lawyer, so don't ever take my conclusions as legal advice. But my sense is that this is particularly pretty broad, and I think it was clever to not encompass it strictly to AI, because obviously there are lots of forms of automated decision making that don't involve AI. But the question may really hinge around the data that they, both the data they ingest and kind of the decisions they make, and whether there needs to be, whether there's kind of an overlap between those two things, or the extent to which your training data includes personal information, even if it doesn't necessarily render a personal decision or judgment, or again, the extent to which your system ingests personal information in the process of using it. But we'll let the lawyers kind of hash out some of the details there. But I mean, I do think this is really significant, and it, to the extent that it involves or will touch things like generative AI. Again, I don't know if everybody heard what I had said earlier about generative AI. But given the broad scope of data that generative AI systems are scraping, just as an example, this could have some impact on data collected in that vein, potentially, just because of the diversity of data that we think is being scraped by these systems. Of course, this is part of the problem. We don't know. There's no transparency right now. And I don't think actually CCPA will fix that problem per se, unless, again, the regulations specifically end up addressing the data that goes into these systems. I don't think ADPA touched on this point. And so this is one of those gaps that I am concerned about with regards to privacy, AI, and of course, if we do pass something like ADPA on the federal level, whether we begin to close these things. So that's a big concern. And I'll stop there.
I agree with your concern, Dr. King, because I work with a lot of members from our organization from 55 countries across the globe. And a lot of them talk about their tools, that it can do a lot of things. And when I ask them questions about the data integrity of, where they acquired it, how did they acquire it, and a lot of them say that, yeah, they got it through. They don't spell it out, but when you question them enough, you know that it was scraped from the web.
Right.
So obviously, there wasn't all that explicit consent around that data acquisition. And so I think you're right on target. It's a big concern. Especially for me, I always think about scraping as a very big red flag. So you work at Stanford, and your organization recently hosted legislation directors from Congress to better educate them on AI. What is needed from an education perspective to make sure that AI is properly regulated?
Sure. So I work for the Stanford Institute for Human-Centered Artificial Intelligence, and we've, for the past 3 or 4 years, hosted a congressional boot camp where we have members of Congress's staff come out, and we give them essentially kind of a boot camp primer on all different aspects of AI, run primarily by faculty at Stanford. And so that's an effort to bolster the kind of the background understanding of the staff members. It would be ideal, I guess, to potentially hold the same type of boot camp for members of Congress, and Representative Khanna might have thoughts on that as well, since he knows his colleagues far better than I would. But certainly, I don't necessarily think that all members of Congress need to understand this at a deep level per se. But the greater kind of congressional, what's the word I'm looking for? Staff and kind of ecosystem definitely needs that expertise, even if individual members don't have it. Sometimes you hear folks joke that you need software engineers kind of running for Congress, and I don't think that's necessarily the best solution. But it would be nice to see some more tech fluency. But I would argue that part of that is also about trying to attract that talent and that expertise not only to the Hill but also to our administrative agencies, so that expertise is there to both advise Congress and to make kind of well-informed decisions.
All right. Thank you very much. So let's now take some questions from the audience. I gathered them up. And so the first one is for Ro. Ro, how are we going to address intellectual property issues in generative AI where purpose of internet publishing is not the mass copying of data?
Well, it's a big issue. First, to Dr. King's point, I mean, I do think having a orientation out in the West Coast as opposed to at Harvard every time where the freshmen go would make sense for members of Congress. I don't think you need software engineers. I think you need people who use the technology. It's surprising to me how many people will say, oh, I don't even know my own Twitter handle because my staff does that. Not to say that people should be on X or Twitter all the time, or I've never been on Instagram, or I've never used these tools. And it would be like if you had people making rules of the road who had never driven or had never been in the passenger seat. So to me, it's not understanding the details of technology as much as having a familiarity with it and using it so that there's a comfort level in understanding what the issues are. Very hard to talk about privacy in the abstract if you actually haven't been on the apps that are causing the issues. In terms of the intellectual property, I mean, that's a big issue, and that is if you have a song and you have art and it's out on the internet, and now you have some AI machine come in and combine that with other pieces of work and put something out, what should the compensation be to the original content generators? And what is fair use or not? I mean, all art in some sense is derivative. The great writers read a lot of other works and cite them and work off them and contradict them. So all work in some sense has a derivativeness, but it also has an originality. And these are going to be, I think, some of the difficult issues legally in what the compensation should be for the use of things that are being combined with AI. There obviously should be some. And where is the fair use of things that are in the public domain? And I think that that's going to have to be sorted out both through the law and through the courts.
Thanks, Ro. Here's one for Alastair. Alastair, how do you respond to privacy advocates who point to consent fatigue as a counter-argument to consent-based frameworks as an alternative to banning the sale of a whole category of information like geolocation, for example? Is guaranteeing the legitimacy of a global opt-out the best response there?
So I do think that consent fatigue is real. I mean, no one likes pushing all the buttons, clicking it every time. As I've said, I think we are not yet at the promised land of where it's understood. The same way we now would think, oh gosh, if people listen to your phone calls, that would be a bad thing. But it took decades before we had a good federal wiretap law. So I think we will get to a place where the global opt-out is accepted. At the same time, when we were drafting the law, we spent a ton of time with legal experts. The problem is, and it's not a problem, it's actually a feature of the country, we have the First Amendment, and companies have the First Amendment right too. And so there was a 2010 case, IMS versus Sorrell, and many people said that was the death of privacy. It was a Supreme Court case. We spent a lot of time trying to create a law that would survive court challenges. And so we think there's it's it's uncontrovertible that if you give the consumer the right to do something, that is a much stronger framework than telling the company what they can or cannot do. They cannot sell this data or whatever. And so trying to structure our law around the framework that was there in American jurisprudence, I think achieved that. Someone who's super helpful was Chris Hoofnagel, a local privacy lawyer. He's a professor of law at Berkeley. And he was very helpful about helping us to structure the law to make sure that we were in a good place for, so we couldn't be sued and thrown out, because you can pass some initiative that's great, but if you get thrown out, it doesn't matter. And so allowing consumers to do something with their data, to tell a company, hey, I don't want this to happen with my data, is a much stronger way, much like the do not call list when it used to work, on my phone. So, you're trying to go down that there again with your Delete Act, Tom, which is for those people who don't know, it's in the process right now in California. We hope it passes. I've been working with Tom on that. So anyway, that's my answer there.
Thank you. So another one for Ro right here. Can you speak a bit on the voluntary agreement that the Biden-Harris administration secured with OpenAI, Amazon, Google, et cetera? Aside from the fact that it's not codified, what is missing from these types of agreements that especially the one just recently that the Biden administration did with the major players?
Well, one, there's no enforcement, so it's taking these companies at their word. I have a lot of confidence in the companies, but there needs to be some enforcement. Second, there's a lot more that needs to be done. I mean, what the companies have agreed to is that there's going to be a safety check, a human check, that they will appropriately label AI in terms of AI created content versus human content. But there are questions which have come up on intellectual property and what happens there. There are questions that have come up in terms of what should be open source or not. There are questions on what can we do concretely to guarantee the safe data sets being used, and what disclosure needs to be made about what data is being used. So I think it's a good start, but it's certainly not comprehensive.
Okay, we got our last question. This is for Jen. We seem to have a consensus on ethics for AI and a broad range of principles, standards for AI. Should we encourage putting together national and international auditing standards during the development of AI solutions?
Yeah. I think I agree with that off the top. Auditing transparency is going to be the biggest challenge with AI, and that was actually one of the things I wanted to add in earlier. Both on the audit side, really at all stages, like the data side, what data goes into it, the black box itself, like trying to peer inside, understand what's coming out, and certainly in terms of auditing the outputs. And from the privacy perspective, one of my biggest concerns with transparency is the explainability piece, because again, we don't know how AI, in many cases, how these different algorithms are coming to their determinations, and not even the people who design them and program them understand either. And so, so if we don't have a good system for really understanding how these things decide or make the classifications or predictions that they do, then either we need to decide that we're not using this technology in certain circumstances because it's too high risk, or that we just can't, without an explanation, you shouldn't be allowing these things to make determinations, especially ones with legal risks, or we need to really figure out the whole transparency pipeline to understand whether that gives us enough information to really be able to piece together why it's giving a particular determination or output, even if we don't fully grasp precisely why it is doing so.
Great. Well, thank you everyone so much.
Tom, can I just add one thing to Jen's comment there? One part about the California statute is it requires in terms of the AI regulation, it requires the provision of substantial information about the logic involved. So it helps that transparency argument a lot.
And Tom, I just want to say, because you're too modest to say it, but people should read your book. It covers a lot of these very complex issues in a way that is relatable, that is thoughtful, and that, whether they agree with it or not, I think will provoke the type of thinking that we need. I read an early draft of it, was very, very impressed with it. And I really hope people will read it, and more than that, engage with it. Maybe comment on LinkedIn or send comments to some of the panelists. It's been an honor. I've learned a lot on the panel, but I do want to make sure people know that they should check out your book.
I'm definitely blushing here. So thank you so much to everyone. So thank you to Shilpi and her organization for co-hosting. Thank you to Representative Khanna, who's my friend Ro. Thank you to board member Alastair Mactaggart, who's a friend. And Jen, you're now a new friend as well. Dr. King, I appreciate it. And again, Shilpi and Steve in the background right there as the producer. And again, as Ro said, if you want to get a copy, it's called Containing Big Tech. And my name is Tom Kemp. So thank you, everyone, for joining, and have a great day. Take care, everyone. Bye-bye. Thank you, everyone. Hey, Steve, thanks.
Thank you, Tom. This was great.
Yeah, we had some technical difficulties. I don't know if it was Jen's or whoever's, but it is what it is. So thank you so much.